disputes, documentations like emails, variation orders, and site notes are absolutely critical. So looking at the incorrect options then, option A suggests merely denying allegations without providing evidence. So this falls short of what the CPR rules expect, which are detailed and substantiated responses. Option B recommends negotiation, which is generally sensible, but not as a replacement for filing a formal defense. The better approach is to file your defense first, then explore settlement. Option D suggests delegating responsibility to a legal advisor. So while legal advice is valuable, it doesn't address what the response should contain. And in small claims track cases, cost recovery for legal representation is quite limited. Option E, ignoring the claim, is the worst possible approach because this would almost certainly result in a default judgment against Oliver here. So this question highlights a fundamental principle in civil litigation. Respond promptly, substantively, and with evidence. So your defense must directly address the specific allegations and be supported by documentation where possible. So remember that the courts expect parties to be forthcoming with information at an early stage. A well-evidenced defense not only strengthens your position in court, but it often forms the basis for successful settlement negotiations. Moving on to question 5. Victoria, a freelance logo designer, is facing a claim from Brightwater Ltd, who alleges that the corporate identity package Victoria created contained elements that closely resemble existing registered trademarks, potentially exposing Brightwater to infringement liability. Victoria has responded with a counterclaim for $3,750 unpaid fees, maintaining that Brightwater has yet to pay for completed work. As Victoria prepares her legal strategy, she must determine the most effective approach to the proceedings. Which of the following approaches would be most appropriate for Victoria to take? So A, Victoria should file a response to Brightwater's claim, providing evidence of a design process, including initial concepts, development sketches, and digital timestamps to demonstrate originality. B, Victoria should offer Brightwater a full refund of £5,000 for the design work, believing this will shield her from further legal complications and preserve her professional standing. C, Victoria should commission an independent intellectual property expert to assess the originality of her designs to bolster her defense and counterclaim, believing expert evidence would strengthen her case. Or D, Victoria should apply for the court to strike out Brightwater's claim immediately, arguing that there is insufficient evidence for the allegations of trademark similarity. Or finally, E, Victoria should disregard Brightwater's claim, confident that her portfolio demonstrates her creativity and that the court will recognize her professional integrity based on her previous work. So, this question examines how to respond to an intellectual property claim in a contract dispute. So, in our scenario here, Victoria is facing allegations that her design work resembles existing trademarks, while she's also pursuing payment for her services. So, the question tests your understanding of civil litigation strategy and evidence. So the correct answer here is A. Victoria should file a response with evidence of her design process, including concepts, sketches, and timestamps to demonstrate originality. So this answer highlights 3 critical elements of effective civil litigation. First, it ensures procedural compliance. So when served with a claim, you must file a defense within the required time frame, like we've already mentioned, typically 14 days, though it can be extended by 28 days if you're filing an acknowledgement of service. So failing to respond could result in a default judgment. Second, it addresses a substantive allegation that the designs weren't original, providing evidence of a creative process. So Victoria directly counters the central claim against her here. Third, it recognizes the importance of the evidence. So in intellectual property disputes, documentation showing how designs evolved can be powerful proof of independent creation. So looking at the incorrect answers. So option B suggests offering a refund. This could be interpreted as an admission of liability. So it may damage Victoria's defense and counterclaim for payment. Option C recommends seeking expert opinion. So while potentially useful, this shouldn't delay filing a response, and experts are typically engaged later in proceedings. Option D proposes applying to strike out the claim immediately. So this is rarely successful without strong grounds and supporting evidence, which Victoria needs to compile first. Option E suggests ignoring the claim, always a dangerous approach here because that would likely result in judgment against Victoria. So in practice, designers and other creative professionals should maintain detailed records of their process. This creates an evidence trail that can be invaluable if disputes arise. So such records might include initial briefs, concept sketches, client feedback, revisions, and final deliverables. So this question illustrates a broader principle applicable to many professional disputes. Respond promptly, address allegations specifically, and provide evidence rather than mere assertions, okay? Moving on to question 6. Marcus, a management consultant, entered into a 6-month contract with Eastbrook Enterprises Limited to provide strategic guidance on market expansion. After 4 months, Eastbrook alleges that Marcus's advice has resulted in a 15% reduction in quarterly revenue and is demanding repayment of his £28,500 consultancy fee. Marcus contends that Eastbrook selectively implemented his recommendations while ignoring crucial elements of his strategy, and that any financial shortfall stems from the incomplete application of his advice. As Marcus considers his response options, he must determine the best and the most effective approach. So which of the following approaches would be most appropriate for Marcus to take? A. Marcus should prepare a comprehensive document outlining his recommendations, evidence of the communication to Eastbrook, and Eastbrook's partial implementation to demonstrate that he fulfilled his contractual obligations. B. Marcus should propose returning 30% of his fees to preserve his professional reputation and client relationships, despite believing he is not at fault. C. Marcus should immediately file a counterclaim against Eastbrook for breach of conduct, arguing that the selective implementation of his advice constitutes the actual cause of their financial underperformance. D. Marcus should seek legal advice to clarify his position under the consultancy agreement and understand the potential implication of Eastbrook's claim. Or E. Marcus should dismiss Eastbrook's allegations, relying on his established reputation in the industry and previous successful consultancy engagements to vindicate his position. So do give me your answers in the comment sections. So in our scenario, Marcus provided strategic guidance to Eastbrook Enterprises, who now claim his advice led to poor financial performance and want their fees returned. Marcus believes the issue was their selective implementation of his recommendations. So this question looks at management consultant facing allegations that his advice caused financial losses. So the correct answer here is A. So Marcus should prepare a comprehensive document outlining his recommendations, evidence of their communication, and Eastbrook's partial implementation. So this answer highlights several key principles that apply to professional services disputes. So first, it recognizes the critical importance of documentation. In disputes involving professional advice, Records of what was recommended, how it was communicated, how it was implemented are often decisive, so this documentation forms the foundation of any defense. Second, it addresses causation, the crucial link between the alleged poor advice and the claimed losses. So by documenting how Eastbrook selectively implemented his strategy, Marcus can challenge whether his advice truly caused their financial shortfall. Third, it focuses on the contractual standard of performance. So remember that consultants are generally obliged to exercise reasonable skill and care, not to guarantee specific outcomes. So documentation can help establish that Marcus met this standard. So looking at the incorrect option, so option B suggests offering a partial refund, which could imply acceptance of liability and potentially undermine Marcus's position if matters escalate to litigation. Option C recommends immediately filing a counterclaim. So while this might eventually be appropriate, it's premature without first establishing a solid evidentiary foundation at this stage. Option D suggests seeking legal advice. So while certainly prudent, this alone doesn't address the substantive allegations about Marcus's performance. Option E proposes dismissing the allegations based on professional reputation. This is quite risky and it fails to engage with the specific claims being made as well. So this question illustrates a fundamental principle in professional practice: maintaining comprehensive record of your work. Client interactions, client decisions are your best protection against disputes. So for consultants especially, documenting when clients deviate from your recommendations can be crucial if outcomes later fall short of expectations. So in SQE assessments and in practice, remember that evidence gathering should precede formal legal responses, and documentation creates a foundation for effective dispute resolution. Moving on to question 7. Emma is preparing for a land dispute case where her client, Mr. Patterson, claims adverse possession of a parcel of agricultural land adjacent to his farm in Northumberland. Emma consults with her supervising solicitor, Miss Harrington, about the advice and the evidence required to establish Mr. Patterson's claim. So which of the following represents the most appropriate guidance Miss Harrington should provide to Emma? So A, Miss Harrington should advise Emma to concentrate solely on collecting evidence of Mr. Patterson's continuous physical possession of land, as this is a fundamental requirement for adverse possession. B, Miss Harrington needs to explain that gathering documentary evidence such as land registry extracts, boundary surveys, and historical title deeds will also be essential to establish the legitimacy of Mr. Patterson's claim. C, Miss Harrington should suggest that Emma disregard any evidence that contradicts Mr. Patterson's claim, as this would only weaken their legal position. D, Miss Harrington must inform Emma that witness testimonies are irrelevant in adverse possession cases, as only documentary evidence will be considered by the court. Or E, Miss Harrington should tell Emma that since Mr. Patterson has been farming the land for over 2 decades, they need only minimal evidence to support his adverse possession claim. So please do give me answers in the comment section. So this question examines evidence gathering and adverse possessions claim. So the scenario involves Emma, who's preparing a case for Mr. Patterson, claiming adverse possession of agricultural land, and she's seeking guidance from her supervising solicitor about what evidence to collect. So the correct answer is B. Miss Harrington needs to explain that gathering documentary evidence such as land registry extract, boundary surveys, and historical title deeds will also be essential. So this question tests your understanding of the comprehensive approach required for adverse possession claims, So let me just explain why option B is the correct answer and what this reveals about adverse possession claims. So adverse possession claims require proving multiple elements, not just one. While factual possession is certainly crucial, documentary evidence provides essential context for the entire claim. So land registry documents establish who holds paper title. Boundary surveys clarify exactly what land is being claimed. And historical deeds can reveal whether there was any agreements or permissions that might defeat the claim. So looking at the incorrect options then, so option A suggests focusing solely on continuous physical possession. So while this is certainly a key element, it is insufficient on its own. We need to establish all elements of adverse possession. Option C suggests ignoring contradictory evidence, which would be a serious breach of professional ethics, because as solicitors, we have duties to the court and to the proper administration of justice that require us to consider all relevant evidence. Option D incorrectly claims witness testimonies are irrelevant. So, in fact, witnesses can attest to the nature and duration of possession, are often critical in adverse possession cases. Option E dangerously oversimplifies by suggesting minimal evidence is needed because of the long duration. The length of possession is just one factor. We must still prove the quality of possession has met all legal requirements. So remember that adverse possession claims under the Land Registration Act 2002 have different requirements than those under the Limitation Act of 1980. So for registered land where possession began after October 2003, Schedule 6 conditions must be satisfied, while earlier cases or unregistered land follow different rules. So in practice, successful adverse possession claims typically combine multiple forms of evidence, so documents showing boundaries and title history, photographs demonstrating use over time, witness statements, evidence of acts of ownership like fencing or cultivation, and potentially expert evidence from surveyors. So this question illustrates a broader principle applicable to many property disputes. So thorough evidence gathering across multiple sources is essential for building a strong case. So question 8. Marcus, a solicitor representing the Greenfield Community Trust, is involved in litigation regarding access to information under the Freedom of Information Act 2000. During the disclosure process, Marcus received a request for internal emails and meeting minutes that discuss the Trust's strategic planning and allocation of charitable funds. If disclosed in their entirety, these documents could potentially damage the Trust's standing with donors and reveal confidential information about vulnerable beneficiaries. Marcus must determine the most appropriate response to this disclosure request while protecting his client's legitimate interests. So which of the following approaches would be most appropriate for Marcus to take? A. Marcus should disclose all requested internal communications to fully comply with the Freedom of Information request, as transparency obligations take absolute precedence for organizations receiving public funding. B. Marcus should disclose only those communications that do not contain sensitive information about strategy or beneficiaries, ensuring partial compliance while protecting the trust's reputation. C. Marcus should apply to the Information Commissioner's Office for determination on which documents must be disclosed, focusing on the potential exemptions under the Freedom of Information Act related to confidential information and personal data. D. Marcus should disclose all the requested records, but include an explanatory memorandum detailing the context of the communications, which might mitigate any misinterpretation of the information. Or E. Marcus should refuse the entire request for internal communications, citing the charitable status of the trust and the confidentiality of its operations as grounds for complete exemption from disclosure. So let's examine this question about handling freedom of information requests when sensitive information is involved. So in our scenario, Marcus is representing Greenfield Community Trust, which has received a request for internal documents that could potentially harm the organization's reputation and reveal confidential information about vulnerable beneficiaries. So the correct answer here is C. So Marcus should apply to the Information Commissioner's Office for determination on which documents must be disclosed, focusing on potential exemptions under the Freedom of Information Act. So this answer recognizes several important principles when dealing with information law. First, it acknowledges that while transparency is important, the Freedom of Information Act contains specific exemptions designed to protect legitimate interests. These include exemptions for personal data under Section 40, information providing confidence under Section 41, and commercial interests under Section 43. Second, it identifies the proper regulatory channel for resolving disclosure disputes. So in England and Wales, the Information Commissioner's Office is the appropriate body to make determination about freedom of information exemptions before judicial review becomes necessary. Third, it demonstrates a balanced approach that neither over discloses nor improperly withholds information. So by seeking an official determination, Marcus follows proper process while protecting his client's interests. So looking at the incorrect option, so option A suggests disclosing everything. So this fails to consider legitimate exemptions and could breach data protection obligations regarding vulnerable beneficiaries. Option B proposes selective disclosure based on Marcus's own judgment, which risks inconsistent application of exemptions and could be challenged as improper. Option D suggests full disclosure with explanatory context, but this doesn't address whether certain information should be disclosed at all under the FOI region. Option E recommends blanket refusal, which is unlikely to be sustainable under the Freedom of Information Act and could expose the client to enforcement action. So in practice, when handling such requests that involve sensitive information, solicitors should carefully identify potential exemptions that apply to specific documents. So consider whether partial disclosure through redaction might be appropriate and maintain proper records of all disclosure decisions. Following the regulatory process demonstrates commitment to both transparency and proper legal procedure. So remember that charitable organizations often have particular concerns about donor and beneficiary confidentiality, but these must be addressed through specific statutory exemptions rather than blanket refusals. Moving on to question 9. Miss Bennett is a solicitor advising Riverside Wildlife Conservation Trust, which is challenging Westshire County Council's decision to withhold environmental impact assessments under the Freedom of Information Act. The case involves significant environmental protection concerns of broad public interest, as the documents relate to a controversial housing development near protected wetlands. Ms. Bennett needs to discuss with the trustees the financial implications of pursuing this litigation, particularly regarding the costs, recovery, and funding options available for this type of case. Which of the following represents the most appropriate advice Ms. Bennett should provide regarding costs and funding? A. Ms. Bennett should inform the trustees that because this is a clear public interest environmental case, they will automatically qualify for protective costs orders that will shield them from all financial risk, ensuring they can proceed without budgetary concerns. B. Ms. Bennett should explain that if they win the case, the court will likely award costs in their favour, but the trust will still need to consider the initial funding of legal expenses, which may present financial challenges. C. Ms. Bennett should advise that while public interest environmental cases may result in costs being awarded against the losing party, there is no guarantee of full recovery, and the trust must be prepared for potential financial exposure throughout the proceedings. D. Ms. Bennett should reassure the trustees that costs recovery is standard practice in freedom of information disputes with public authorities so they can proceed confidently with minimal financial risk. Or E, Ms. Bennett should recommend that the trust apply exclusively for pro bono representation through environmental law clinics, as this would eliminate all financial obligations and allow them to pursue the case without final financial considerations. So do have a go at this, where the question is about cost advice for a charity pursuing freedom of information litigation. So in our scenario here, Miss Bennett is advising Riverside Wildlife Conservation Trust about challenging a council's refusal to disclose environmental assessments. So she needs to provide accurate advice about the financial implications of this litigation. So the correct answer here is C. Miss Bennett should advise that while public interest environmental cases may result in costs being awarded against the losing party, there is no guarantee of full recovery, and the trust must be prepared for potential financial exposure. This answer reflects the reality of costs in public interest litigation in England and Wales. Let me explain the key principles at work here. So, first, while we have the general principle that costs follow the event, meaning the losing party typically pays the winner's costs, this is always subject to judicial discretion. So there is never a guarantee of full recovery. Second, even when costs are awarded, successful parties typically recover only roughly around 60 to 70% of their actual legal expenses. So this creates an immediate shortfall that the charity must be prepared to absorb. Third, charities have special considerations. So trustees have fiduciary duties to protect charitable assets and must make responsible decisions about litigation risk. So let's just go through the other options being problematic. So option A suggests automatic protection from cost liability, which is misleading because while environmental cases may benefit from ERIS convention cost protection, these mechanisms typically cap liability rather than eliminating it entirely. Option B acknowledges some challenges but understates the risk of adverse costs orders if the case is unsuccessful. Option D provides false reassurance by suggesting costs recovery is standard and reliable, which could lead trustees to make uninformed decisions. And option E recommends relying exclusively on pro bono representation, which is rarely practical for complex, lengthy litigation. So, in practice, solicitors advising charities on public interest litigation should try to discuss multiple funding options, including conditional free agreements, after the event insurance, potential predictive cost orders, and staged payment arrangements. So we must provide balanced, realistic advice that enables trustees to make informed decisions about litigation risks. So remember that in the SQE assessments, questions about costs advice often test your understanding of both the technical rules and your professional obligation to provide clear, comprehensive advice about financial implications. Question 10. Sarah is a solicitor representing a client, Mr. Wilson, in a civil claim at the county court regarding a breach of contract with a building contractor who abandoned renovation works at Mr. Wilson's restaurant, causing significant business disruption and financial loss. As the trial date approaches, Mr. Wilson expresses considerable nervousness about the court process, particularly regarding what to expect during the hearing and the significance of witness evidence. Sarah must ensure that Mr. Wilson is properly prepared for the trial experience. So which of the following approaches would be most appropriate for Sarah to take? A. Sarah should explain to Mr. Wilson that the trial will primarily focus on documentary evidence such as the contract and payment records, and that witness testimony will play only a secondary role, so he should not be overly concerned about it. B. Sarah should inform Mr. Wilson that he can effectively present his case without witnesses, as a judge will base the decision predominantly on the written contract and email exchanges documenting the contractor's failures. C. Sarah should prepare Mr. Wilson by explaining the trial process comprehensively, emphasizing that witness testimony can be crucial in establishing the impact of the disruption on his business, and discuss with him which potential witnesses might best support his case. Or D. Sarah should advise Mr. Wilson that during the trial he should remain silent unless directly questioned by the judge, as any voluntary comments could potentially undermine his position. Or finally, E. Sarah should reassure Mr. Wilson that if he submits his invoices and photographs of the incomplete work clearly, the judge will certainly find in his favour, regardless of witness evidence. So the correct answer here is C. Sarah should prepare Mr. Wilson by explaining the trial process comprehensively, emphasizing the importance of witness testimony and discussing potential witnesses. So this answer reflects several key principles about client preparation and witness evidence. So first, it recognizes the solicitor's duty to thoroughly prepare clients for the litigation experience. This includes explaining the court process, the roles of different participants, and what Mr. Wilson can expect during the hearing. So proper preparation helps reduce client anxiety and enables effective participation on their part too. Second, it correctly identifies the critical role of witness evidence in contract disputes. So while documentary evidence like contracts and emails are important, witness testimony is often essential to establish context. So explain technical matters and demonstrate the impact of the breach. So in this case, how the abandoned works affected the restaurant business. Third, it acknowledges the strategic element of witness selection. So some witnesses will be more credible or knowledgeable than others. So identifying the right witnesses is a crucial part of case preparation. So looking at the incorrect options, option A downplays the importance of witness evidence, which could leave Mr. Wilson unprepared for a significant aspect of the trial. Option B incorrectly suggests that written evidence alone is insufficient, which misrepresents how civil trials actually function, particularly in construction disputes. Option D mischaracterizes the client's role in proceedings. So while clients should be advised about appropriate courtroom conduct, they will typically need to give evidence themselves. Option E provides false assurance about the outcome. So this breaches professional obligations to give realistic advice about litigation prospects. So in practice, effective client preparation involves explaining the structure of the trial, discussing what makes witness evidence persuasive, preparing the client for giving evidence themselves, and being realistic about prospects. So this kind of comprehensive approach ensures the client can participate effectively in the case while maintaining appropriate expectations. So thank you for joining today's session on dispute resolution for the SQE exam. If you have any questions or need further clarification, please feel free to reach out regarding the topics we have discussed today. And I will see you in the next session. Thank you.